welcome to Raisina Uphill on TIOL Tube. In this show, we bring you policy changes and developments from the vivid world of the Indian bureaucracy.
Today, we take you through the implications of some legal amendments, a new appointment and a resignation, the power struggles and a court verdict on bureaucratic challenges. But first, let's start with the proposed amendments to the Prevention of Corruption Act.
Whether it's Colgate or 2G spectrum, each of these scams have tutored the government on the techniques resorted for corruption. So even as the former Coal Secretary Mr. H.C. Gupta battles charges of corruption at a more fundamental level, as many as 19 key sections of the Prevention of Corruption Act are sought to be amended. Some of these changes, if passed as amendments to the Act, will restrict the powers of the investigating agencies. Agencies like the police, the CBI or any anti-corruption agency will need the prior approval of a competent authority to initiate an investigation or prosecute any high-ranking public official, whether serving or retired. Retired officials are now for the first time included for protection. Permission of the competent authority would be needed when the case relates to any decisions taken by the public servant in the discharge of his official duties, or even when his assets are disproportionate to his known sources of income. However, there is an exception. No prior approvals would be required if an official is caught red-handed. What do these amendments mean? Can the necessity for sanctions cause delay in investigations or even allow the wrongdoer to tamper with the evidence? Does it interfere with the probe agency's right to investigate a complaint? TIOL Tube spoke with former government officials on the implications of this added protection from investigation and prosecution of public servants, both serving and retired. Let's hear Mr. Sudhir Kumar, a former IPS officer and Vigilance Commissioner of India.
This is a safeguard which has been built into the system to see that there is no malicious action. That if there is prima facie a misconduct which is evident, then and which is evident through a preliminary inquiry or investigation by the CBI or the anti-corruption bureaus, then the competent authority accords approval to investigate, because an investigation, launching of an investigation after the registration of a criminal offence would mean or would amount to abridging the basic or fundamental rights of the individual, of the suspect.
Officers like Mr. T.S.R. Subramanian feel the amendment is too draconian and must be restricted in its scope.
I think this is too draconian, and should be confined only to those segments which are directly involved in policy making. Secondly, it should be confined only to retired and serving decision-making levels. Probably you can define it as a joint secretary and above, including ministers and including prime minister.
Who is the competent authority? Recently, the Central Vigilance Commissioner pointed out in a report of scores of instances where the Central Vigilance Commission had directed investigation in cases of corruption, high-handedness and favoritism. But no action was initiated by the department. Top officials not only overlooked the issues but also tried to cover up the irregularities. These are the top officials who would also act as the competent authority. We asked these former bureaucrats whether the sanction by the competent authority, which would be a government department head where the public official served, or a minister, implies a conflict of interest. Let's hear Mr. Sudhir Kumar.
When you talk of the conflict of interest in the competent authority, then you are actually questioning the credibility of the entire system. What is a competent authority essentially? Competent authority is the President of India, is the Prime Minister, is the Minister in charge. And you see, regardless of who is there in power, the system has to be actually effective. It should decide on merits, and if the accused person is from a certain department and the decision to prosecute is to be taken by the minister of that department, I mean, even in the normal course that has to take place. That's the legal procedure. So you can't say that everyone is untrustworthy, and because the guy is from the same department.
Other bureaucrats felt that the competent authority must be an independent body, not senior officials of the same department. There should also be protection only against prosecution, not investigation, and there should be no question of prior approvals when a public official is found to hold disproportionate assets. Let's hear Mr. Subramanian.
That the decision should not be by the competent authority, so we should create an independent authority for that. Again, we should not block investigation or inquiry. We can only block the filing of charge sheet, because really the case starts legally at the stage of filing of charge sheet. The presumption is if there is a disproportionate asset or undue favors in a particular transaction, no permission, no protection of any kind to anybody should be made available.
What about the adequacy of time proposed to be given to the competent authority for sanctioning the prosecution? Most felt the period of 3 to 4 months was too long.
The default decision is within 2 months. I think 4 months is too much. Within 2 months, approval doesn't come. The approval is deemed to have been given.
Mr. Sudhir Kumar too advocated a shorter time frame.
With the proper application of mind and within a specified time frame, which I understand could be a reasonable time frame, could be 2 months to 3 months or so, and I believe it is being proposed up to 4 months. So if there is a fixed time frame given for the application of mind by the competent authority, then there should be no harm in allowing this.
There are other instances of corruption currently not within the ambit of the anti-corruption law, which are sought to be included. When the public servant may not have benefited personally but has acted to cause gain to another, or he may have benefited in ways that are not obvious to the public. We spoke with Mr. Subramanian Swamy on these amendments, which are currently being opposed by most political leaders.
Attempt is being made. I'm fighting that. An attempt is made to prevent a public servant benefiting a private person monetarily, which is not in the public interest.
Pollution.
Well, I mean helping, which is not in the public interest. The public servant may not have received any bribe.
Right.
All right. But he benefited somebody.
Yes.
And that benefit was not in the public interest. See, if a public servant does something which is not in the public interest, how can there be a good intention? Either you're stupid, which means you shouldn't have been the public servant in the first place, or you are having a benami, that's all.
What happens in such a case when the civil servant is merely following orders?
There is one problem in that, which we have to find some safeguard for. And that is, you see, a lot of civil servants are ordered by the minister, clear this project. And the signature is of the civil servant but not of the minister. Right. So he gets caught. Right. So we have to find a safeguard for that. Under the civil service rules, he must not implement an order which involves monetary gain for anybody unless he gets it in writing.
That's true. Even a Supreme Court order of 2014 states that officers should put all orders in writing. Perhaps even the directions received, which will stand the test of time. Maybe the civil servant rules need to be amended with similar urgency. The entire IAS lobby is supporting Mr. H.C. Gupta, the former Coal Secretary.
The entire IAS fraternity has backed the former Coal Secretary Mr. H.C. Gupta against the charges of corruption, cheating and criminal conspiracy. The IAS lobby has even gotten together and raised a fund for Mr. H.C. Gupta, who had stated that he had no money to pay the legal fees for his trial. He had even sought to withdraw the personal bond submitted for his bail. About 100 IAS officers, serving and retired, have got together with each other, officer contributing rupees 10,000 and collected about rupees 10 lakhs for his upright officer. The IAS lobby has even sought a meeting with the Prime Minister to push for the need to protect honest and well-meaning officers. The IAS fraternity is also planning to intervene in the coal scam matter by filing a separate plea in the ongoing trial. Even the BJP National Secretary has offered to help Gupta. Is the position of the Secretary Textiles jinxed?
The position of the most senior bureaucrat in the Ministry of Textiles seems to be jinxed since the last 5 years, with no secretary enduring this position for more than 18 months. The current secretary, Ms. Rashmi Verma, IAS from the 1982 Bihar cadre, was appointed as Secretary Textiles in December 2015. She was earlier the additional secretary in the Department of Revenue, Ministry of Finance. But within a few months of taking over, Ms. Verma was dragged into a controversy as sparks flew between her and the newly appointed Textiles Minister, Ms. Smriti Irani, known for a stormy temperament. Experts hope that Ms. Verma, who at 58 has age on her side, shall be able to serve for at least 3 years. It would take this long for any impact of the new job-centric textile policy to be felt at the grassroots. But how long will Ms. Verma be able to retain this position? Before Ms. Rashmi Verma, the outgoing Textile Secretary Sanjay Kumar Panda served only for 17 months and retired in December 2015. Before him, Zora Chatterjee worked for just 18 months from January 2013 to July 2014. Prior to that, Ms. Kiran Dhingra got only 1 year from January 2012 to January 2013. We do hope Ms. Verma shall be able to tide through the turbulence with the Textile Minister over the rupees 6,000 crore apparel and textiles package cleared by the Cabinet in June this year. Has the quality of our IFS recruits deteriorated?
There could be some truth in the maxim that India's IAS are ruling the country, because top scorers in the civil services examination no longer opt for the Indian Foreign Services. Candidates with highest ranks go for IAS. Result, the Standing Committee on External Affairs has recorded the deterioration in quality of IFS recruits who have little knowledge of international affairs and almost no aptitude for diplomacy, making it dangerous for the country to have them represent India's interest overseas. The panel has zeroed in on the defects of the system. It agrees that the civil services exam is still to be the best way to choose officers, but needs to include additional tests to assess the candidate's aptitude for foreign services. And we spoke with Shashi Tharoor on the same, the Member of Parliament and former UN diplomat, who also heads the committee. He has some ideas on improving the quality of IFS recruits. Let's hear him.
So we asked for additional weightage in the interview, and what we said was that in our committee we said that either have a different interview of foreign service aspirants, or you give a different weightage for the way in which the person performs in the interview for the foreign service, in which you specifically note these qualities of verbal communication and personal manner that would be an asset in a diplomat, and weigh them accordingly in considering IFS postings. If you pick people who've scored well but are unable to open their mouths, who are unable to speak comprehensibly, who are unable to articulate a thought, then you are doing your country a disservice. We should open up the exam to NRIs. And one of the reasons for that is that there are lots and lots of bright people. I get at least 1 or 2 emails a month from bright NRIs who are prepared to serve India, who are Indian citizens all their lives, but who know they haven't got a chance of passing the UPSC because they've studied abroad, who perhaps can't follow an Indian language at the level required to take an examination, but who have grown up living with foreigners, speaking to foreigners, mastering foreign languages. And so we said anyone who has studied 50% abroad, 50% of the education abroad, should even be exempt from the Indian language. They should come in with a foreign language and they can learn the Indian language the way in which an Indian would learn a foreign language. Another recommendation we came up with was lateral entry, where we said that increasingly a number of skills are found to be wanting in terms of today's reality.
The committee has made these recommendations to the ministry and DOPT and urged it to explore all options to employ the best possible candidates for the foreign services. After all, India currently has 770 IFS officers against the sanctioned strength of 912. Where are India's wave and charismatic diplomats is a question.
There's been no salary hike for armed forces personnel.
More than 14 lakh personnel of the armed forces have been left high and dry, even as 33 lakh government employees are celebrating the 7th pay commission hike and arrears implemented by the government. The salaries of the forces are still unrevised. The pay alimonies are due to the party issues between the various categories of employees within the forces and their civilian counterparts. The yet major issue is unresolved and are the differences in the entry-level pay in each rank of the armed forces, the denial of the higher military service pay for the junior commissioned officers, and even the calculation of disability pension. The government has also refused the grant of non-functional upgrades to military officers, denied promotions due to lack of vacancies in the steeply pyramid-like structure of the armed forces. The representations have been made at the highest level. The LIC chairman wants to quit the company.
The chairman of the Life Insurance Corporation, the country's biggest insurer, wants to quit 2 years before the end of his 5-year tenure. Mr. S.K. Roy, a UPA government appointee, has cited personal reasons for wanting to quit as chairman of the organization where he has worked since 1981. Even as the government considers his request for premature retirement under the voluntary retirement scheme, it is preparing to set up an interview panel to start the selection process for the new chairperson. Mr. Roy was a managing director LIC before his selection as the chairman in June 2013. Similarly, Mr. V.K. Sharma, the senior-most managing director LIC, is expected to succeed Mr. Roy once the Appointments Committee of Cabinet accepts Roy's request for VRS. The other 2 managing directors of LIC are Ms. Usha Sangwan and Mr. S.B. Menak. The selection process is expected to start soon. The High Court has ordered the centre to file its LTC policy.
The Delhi High Court has ordered the centre to correct the errors in the leave travel concession scheme and file its LTC policy before the court. The scheme was being allegedly misused, especially relating to the air travel to foreign destinations, which often cost less than the airfare to domestic destinations. The court, hearing a public interest litigation, has directed the centre to streamline its policy and file an affidavit that includes the air travel component applicable over the country. The next date for hearing is scheduled on September 19th.
There's been a clarification from the Rashtrapati Bhavan.
The Rashtrapati Bhavan has issued a clarification that there are no stagnant pools of water on President's estate, which could cause mosquitoes to breed and cause dengue and other waterborne diseases to residents. The clarification came in response to reports that the NDMC had issued 52 notices to Rashtrapati Bhavan since January 2016. The Rashtrapati Bhavan may perhaps be amongst the few truly elitist areas in Delhi without any single report incident of dengue.
On this note, we conclude this bulletin of Raisina Uphill. Thank you for watching.
We look forward to your suggestions and feedback at editor@tiol.in. Goodbye until next fortnight.